Hey, Brian Parker here with another exciting video. I actually woke up with this idea last night. I watched a real snippet of a bad movie. Well, maybe it's a good movie, but it's called 10 Things I Hate About You. And I thought, oh, what are 10 things that a debt collector hates about you? And me, definitely me. So I thought I'd take a look and give you 10 things that I know in my head that debt collectors hate about, let's say, the unrepresented person or even clients that I represent. So before I go further, I want you to remember two things. Number one, don't forget our enhance button. On killdebt.ai, you go to the prompt. So when you're writing in the search of the documents that you want killdebt.ai to produce, it's called a prompt. So let's say you write one sentence. I got a debt collection letter. If you press what we have an enhance button in that same search box, it'll have a big rocket ship on it. You press that and it'll populate so the question will be better asked for you. That's how good our AI is. It even tells you the best way to ask a question so you don't have to sit there 3 or 4 times, which you might want to consider doing to get the best results. So let's say you put in a request or a prompt and it produces something like, meh, just say, hey, could you do a better result on that? And it'll keep working till you get the result you want and you just add your facts and law. Or you start the prompt by downloading the complaint against you. Hey, can you give me a good answer? Oh, pretty good. Can you add this? Can you add this? Can you add Wyoming? Whatever it is. So if you press that rocket ship enhance button, it'll ask a better question of the AI for you, and you'll get better results to print and make your own. So that's number one. Number two, I'm giving you the top 10 things debt collectors hate about you. Number one will be at the end. That's how we're going to do that. But looking through a prism, I want you to look at the top 10 through the following factors. Number one, read the room, read the tea leaves. That means if you're sitting in court one day and you see a judge, he's being very favorable and neutral to debtors or defendants, and he's giving the other side a hard time. It happens. It goes both ways. Unfortunately, it swings the wrong ways a lot more. Well, if it's in your favor, now you might want to consider using these top 10. Number two, is the judge listening to your arguments? That's a consideration when you consider using one or all of these top 10 I'm going to give you. The other side has no documents. This all should be up, Cindy. Cindy's my editor. Shazam. There are no documents on the other side, and they use the wrong name, or it's even ID theft. Now these top 10 I'm going to give you are even better. You know you haven't paid in the statutory limitations. Like in Florida, it's 5 years if you haven't paid on a credit card. Now you cannot be sued on that. So if you know you haven't made a payment in 6 years and you're being sued, hey, read the room. You got a good chance of using these top 10 I'm giving you. Robo-signing, it happens. Now there are two kinds of robo-signing. Back in the day when I did debt collection defense, and when I say back in the day, that's it's about 15 years ago, trying to keep people in their house. A lot of my cases that I won were bought on the fact that the banks, there are certain people that robo-sign, they had a whole complex of people robo-signing documents. I got so good where I actually knew each one intimately. So if you've got robo-signing, which is the second way of robo-signing, today, especially with these Fintech loans, nobody signs anything more. It's an electronic signature, or it's a squiggly bunch of numbers. Well, that isn't always a good signature in some states. So if you've got that on your side, that's a prism to look through as to whether these top 10 things debt collectors hate about you are going to be effective. So number one, Shazam, they cannot stand consumers who show up and fight the case. Because why? So let's say you're being sued. Average lawsuits are about $5,000 or $6,000. So if you're getting sued for that, the debt collector is only going to make a percentage of that, maybe less, meaning they won't get their hourly, and maybe some firms do 25%, but they get competitive. They really want the big account, so go, hey, we'll do it for 20%. Well, if you show up, now they have to go to court. Now they have to respond to pleadings. So again, let's talk about what we always talk about. Two things you always talk about. Up to 9 out of 10 Americans don't answer the collection lawsuit and it gets defaulted. That's what they want. And also, if you will, an educated consumer is their worst nightmare. So, and that is gaining leverage. We always talk about how we gain leverage, and we'll talk about it some more. So if you file an answer, or even what I profess, if it's really good, if it's one of those top 5, a summary disposition saying, they got no case, that causes them money and problems, and they'll want to settle with you because you've just created leverage. Number 9, Shazam, letters to the collector attorney's client. So if you send validation letters out to either the law firm or the client, whoever that is, legally, and you can ethically do that because they're seeking a debt from you, you're allowed to do a validation letter or some other letter that I give you. But how debt law firms get around that, a lot of them just will sue you without sending you any letters. That doesn't stop you sending out those letters. Remember that. There's the most important way to respond to a lawsuit is the answer and counter affidavit and affirmative defenses, but you can still send those letters, and I've done tons of videos on that. One of my favorites is what debt collectors hate about you is if you ask for the forward flow agreement from the bill of sale or assignment. Let me just to remind folks what a bill of sale forward flow agreement is. Shazam. So if you look at that highlighted area, account purchase agreement, forward flow, that's what, it has many names, account purchase, master sale and purchase agreement, all these bills of sale and assignments, and I'll read the second paragraph for you. For value received in further consideration, the mutual covenants and conditions set forth in the agreement. So a real weak link against debt collectors, and this is why they hate you, is if you ask for the forward flow agreement. The forward flow agreement is a master agreement between the buyer and the seller detailing how much is paid, the rights and responsibilities as usual, reminding the buyer, which is the debt buyer, you're getting this without recourse. You can't sue us, and we're not even going to give you merchantability of title, which means the thing we give you, we can't assure you we even had title to it, in a sense. So, but all that stuff is hidden. The price, everything, how much they paid per debt of the millions of debt they bought with the master service and purchase agreement, forward flow agreement. But, so they will guard that like Fort Knox. They do not want you to have that. But the way around that, a couple of ways, is to say, but the bill of sale, which is attached, says pursuant to the mutual covenants and conditions set forth in the agreement. They all say that. Pursuant to the terms and conditions of the master agreement. They all say that. They have to say that. The bill of sale cannot stand on its own. It has to be pursuant. And you will never see that forward flow. So put that on there. That will be their proverbial throat. If you go for that, debt collectors will hate you. I've got letters for you. I've got a discovery. I'll attach discovery to this video on how to get it. And you'll settle the case. That's freaking leverage. Trust me on that. Let me put you up another bill of sale, then I'll move on to number 7, Shazam. I just want to highlight, this one says, for value received and subject to the terms and conditions of the master purchase and sale agreement. So that's everything for you. If you're in a pickle or not, you just want to settle this, go for that. I have a bill of sale and master service agreement forward flow letter attached to this video. Start it out, at least start asking for it. And you can say down the road, hey, I asked for this because it says right in the bill of sale that they say is proof, so I have a right to this. And you do. So use our forward flow letter. 7, Shazam. Number 7 thing that debt collectors hate about you is if you counterclaim. Why? It's leverage, baby. Remember we just did a couple of videos. We just did the one with John, Citibank got whacked. He front-loaded his response. He got a mutual walkaway on a credit card. That's a very rare thing to do. So go after your FDCPA or your state collection statute and seek attorney fees, costs, whatever it is you're going for. That debt will get settled. Debtors that stand their ground, number 6, debt collectors hate that. They think And seriously, that's why that 9 out of 10 rule applies. A lot of the 9 to 10 of Americans that settle, of the 10 debt collection lawsuits that are filed, the law firm is bullying someone that's already on the ground. I know nice debt collectors. They're some good people. I get along with them. But there are freaking bullies too that are also debt collectors, and they live on bullying and holding the person down while they're down on the ground and forcing them into settlements. But if you stand your ground and fight back and say, nope, you want 5,000, I'm going to pay you 1,000, or whatever the leverage you have that gives you the lower amount, stand your ground. Just don't be frightened. Just stand your ground. Debt collectors hate that, because eventually they have to prove they have the right to sue you. And number 5, burden of proof is how they prove they can sue you. And your burden of proof affidavits detailing answers that show, hey, wait a minute, you haven't proven your case. Even with creditor cases, they will bring cases without the original contract or the wrong one. They'll make up affidavits to explain why they don't have the contract, and the affidavit will screw them up. Or our beautiful securitization, that is all leverage. So a burden of proof, I just want you to be clear, and this is going back to what I was talking about, know the court, know the judge, and reading the room. No matter what, the plaintiff has the burden of proof. So you don't have to prove anything. You can disprove, and that's the basis and genesis of what I do, but they have got the burden. It is a burden. They would prefer not to sue you, but if they do sue you, they want to get a default. So the burden is on them to show a full chain of title, and that's a tough burden. And my counter affidavits, my ways of doing answer, going through killdebt.ai are the perfect rebut to their burden of proof, and it makes them work. Now this is going to sound strange. Number 4, debt buyers, debt collector attorneys, no one's going to believe me, don't like fintech debt. Now, fintech is Cross River, Finwise, Upstart, WebBank. There's a ton of this out there. They're quick personal loans you can get within less than 48 hours. Ton of money, but high interest rates. But you need them. Something's going on and you need that, and it's taking care of a bigger problem. Well, they immediately securitize these things, unlike credit cards, and where they have to go through the origination process and set up a trust. That's the part of the fintech process. So they securitize the debt. It gets paid off. It just goes through I've read all the paperwork on securitization of fintech loans. It gets sliced and diced, man. So by the time the debt buyer I can't say it like this, but the paperwork is less than credible that says you owe the debt. So they don't like that because they're already set up before they get the account to go sue you with. Set up in they never got the right paperwork, and they've kind of got to, I litigate against these guys all the time. They will say it's this, and then suddenly turn on a dime and say, oh no, it's really this, because I feel in a little bit way, I feel bad for them because they've got to support a lie, and a truth is a sentence, a lie is paragraphs. So number 3, they just don't, I can tell they do not like fintech. They don't like fintech lawsuits when I'm on the other side, because it's easy pickings, and it's easy pickings for you. Number 3, this is serious, Shazam, anything that threatens a debt collector losing a big account. So normally the attorneys you face from a debt collector case, from the debt collector law firm, are these newer attorneys or someone that doesn't want much out. They just want a 9-to-5 job, don't want to think about the job. It's just, why not? Why not? Why do we need stress all the time? So they're not pushing the gas pedal that much, and they're not too concerned about anything but getting through the day and not having to worry about the job. So if they do something that screws up the case, but also screws up the client, the debt collector law firms are very competitive. They want the big client, the big creditor. They want to pursue these big cases, and they'll give really good deals to keep the account. But I've seen it. The attorney can screw up a major account, and I'm in the middle of one right now where I had to do a motion to compel, But I knew from day one that he was going to ignore the case. So I just kept doing things where his ignoring the case or forgetting about it made him look worse and worse. So we went to a hearing for a motion to compel. Judge gave me everything I wanted, and he's in a, I can't even get a hold of him now. And I always worry, this guy's going to lose his job eventually. But the thing is, this particular law firm, they have these lawyers that don't seem to care. They just want to fill a spot. They harass them for a couple of years and the attorneys move on. And I know this because I have a couple of friends that have gone through this mill of this law firm telling me exactly what's going on there. So I know the buttons to push. And they will, the biggest button is if you can do something to where the client hears about it, that the attorney did this, they may lose it, and they protect the, again, that's a Fort Knox protection. So if you have a chance and to mess with them and mess with their client legitimately, because they're messing with you, do it. That's almost number one of their biggest fears, losing a very good client. Number two, Shazam, standing arguments and discovery. My famous line I just came up with, a lot of dumb stuff that I come up with, which are short and kind of cute, like plunking was one. Another good one is use their documents against them. Well, my favorite right now is DOA. DOA, which means dead on arrival. Hey, let me give you this good idea. Ooh, Bob, dead on arrival. Well, we've come up with dead on assignments. If you can keep saying to the judge, hey, the standing here is off the charts. This case was filed, DOA judge, dead on assignments. He or she will get that. It encapsulates probably 400 of my videos. Dead on assignments. Just keep saying it, right? Whether they may say, hey, will you stop saying that? They got it. Think about it. The case is dead on assignments, because it really is. So the number one thing debt collectors hate about you, what they really hate about you and what's embarrassing to them, is losing against you. Remember that video I just did? Let's put it up there. Shazam. Citibank just got whacked. And that's about John. That did is some of the things I was just telling you about. Just kept pushing the gas and sticking to his guns, even where the judges said, I want to step back here. They get it. Debt collector, that was a major client. The attorney did not want, that's a perfect example. John got the whole debt wiped out with a creditor, Citibank, because the attorney does not want to mess with the clients. Say he's just an attorney. There's a boss that runs things that depends on a good living having that client. So the attorney doesn't want to lose his job, and he'll just walk away from the mess. So the large premises of why a debt collector or debt collectors succeed, and there's that 9 out of 10 rule, is fear. We all get scared. It's a major thing. Oh shoot, a debt collector's coming after me, it's gonna kill this, gonna do this. Well, those days are over. With this video, with your intelligence and your education, and I mean that. I'm no different than you. I was not that you're a big dummy, but I was a big dummy and got into trouble. But today, I actually get to sue some of the guys that went after me 20, 30 years ago, and I step on the gas. So get educated, as I did, as you are educated. You are the number one thing about the debt collectors hate about you. Your education. You're going through this video, whether you use my free stuff or go to killdebt.com and killdebt.ai. By the way, killdebt.ai is free when you used killdebt.com. Also, it's taking time, but I'm creating a database of every FDCPA case I'm trying in the US. And that will be free on killdebt.com. That's coming. The enhance button, that's free. That helps you write your request so you can get your document that you need quicker. So you become the number one thing that debt collectors hate. You become educated, and you fight back. And as I said earlier, stand your ground. So attached to this lawsuit, attached to this video will be a checklist I just created a couple of videos ago on how to properly, the process from I got my lawsuit, or before I got my lawsuit, we know we did that great video on what to do before you're sued using garbage time. Let's put that up there. But the checklist is attached to this video tells you from soup to nuts. Here's what I do once I get the lawsuit, to the very end, how to get it to court, how to file with court. My validation letters, you love those. The securitization letters to fintech companies. You want to always keep pushing on clients and other companies so that the debt collector lawyer is like, okay, just go away. The forward flow agreement letter, just explained to you how important. That forward flow agreement request from the court would be number one if you can automatically get it. They're gonna fight you, but the best way to fight is to send your letter at the beginning, and you can always go through the court system showing, look, I tried over here, and it says right in the bill of sale, it's pursuant to the forward flow agreement. They can't say that the bill of sale is that important to prove they own it, and then ignore the very part of the thing that powers them to say they own it. They can't. They just can't. So you'll settle that case. That's leverage. Discovery requests, DOA, dead on assignments. If you're in litigation, go for that forward flow agreement, but the discovery request on an assignment case against the debt collector, that is on this video, attach this video in Word for you to use in your case. And of course, the show notes. So like, love, and subscribe, and hope this, I did this video kind of tongue-in-cheek, but as I wrote it, I'm adding stuff and I'm really educating. I thought it was just gonna be a cheeky video, but there's some good stuff here. I'm actually liking my own video. Just remember DOA, and remember killdebt.ai with the powerful rocket ship enhance button. Good luck, thank you.